Good morning and welcome to the Senate Committee on Commerce and Labor. Madam Secretary, please take the roll.
Senator Daley, Senator Ellison, Senator Flores, Senator Lang, Senator Rogish, Senator Scheibel, Senator Steinbeck, Chair Pizzina.
Present, thank you so much, and please mark Senators Daley and Flores present when they arrive. Welcome to the members of our audience here in Carson City. I don't see anyone in Las Vegas, though they're welcome if they decide to come this morning, and those following along online. Before we begin, just a few housekeeping reminders. First, I'd like to remind everyone to please silence all of your electronic devices while in the committee room. Members of the public may provide testimony in various ways, all of which are listed on the agenda. You may also submit public comment in writing, either in addition to testifying or in the place of. If you wish to testify in person, please do sign in at the table by the door and provide our committee secretary with your business card. When testifying in person, please turn the microphone on to speak and off to listen, as we'll have those following along online and maybe down the road, some that are listening in Vegas as well. And please do state and spell your name for the record. Anyone who'd like to receive electronic notifications of scheduled bills and access to the committee's meeting materials may do so by signing up on Nellis on the legislative website. Committee members will be using their laptops to view handouts as well as other exhibits, so please do not view this as a sign of disrespect or inattention. And with that, we are going to move to our first agenda item. We will be taking our items out of order today. We're going to start with Assembly Bill 512, then move to Assembly Bill 177, and finally Assembly Bill 319. But right now, we'd like to welcome to the table Mr. Abney and his co-presenter on Assembly Bill 512, which revises provisions relating to casualty insurance. And you may begin when you're ready.
Thank you. Good morning, Madam Chair, members of the committee. Good to see each of you. For the record, Trey Abney, T-R-A-Y-A-B-N-E-Y, here on behalf of Legal Shield. Next to me is Mark Nelms, Vice President and Assistant General Counsel for Legal Shield, and we are here to present and support AB 512. Madam Chair, with your blessing, we will have Mr. Nelms briefly walk through the background and reason for the bill, and then I will walk you through the bill, which should not take very long at all. So I'll turn it over to Mr. Nelms. Thank you, Madam Chair.
Good morning, Madam Chair and members of the committee. My name is Mark Nelms, M-A-R-K-N-E-L-M-S. As Mr. Abney said, I'm a Vice President and Assistant General Counsel for Prepaid Legal Services, also known as Legal Shield, and we do support Assembly Bill 512. I'm very proud of our company. We've been providing legal plans now for over 53 years. Some may not be as familiar with legal plans, and so I'll talk about those. We've actually started doing business in Nevada in 1987, so I'm very proud of that record as well. In 1995, the law firm of Dempsey, Roberts, and Smith, the current provider law firm for the state of Nevada, began providing services. What's important is Legal Shield ourselves, the company, does not provide the legal services. What we provide is access to legal help for members who have a legal plan. And that word access I'm going to talk about later because that's very important when we talk about access to justice and the real issues that states are having in providing that for their citizens. To describe a little bit about how the legal plan works, if you have a family legal plan, you can contact your provider law firm and receive a consultation on any personal legal matter you may have. They can review documents for you. They write letters or make phone calls on behalf of members. They can prepare your will or their estate planning documents, and there's many other benefits as part of that membership. What's important is our provider law firm model is a non-indemnity type legal services plan. So we don't indemnify a member for legal fees. We don't pay claims. We don't reimburse members. So this proposed legislation will simply bring clarity and modernization to the law and will exempt modern non-indemnity legal plans from the insurance code. This will align Nevada with the vast majority of states. Right now, there's only 6 other states, those being Alaska, Massachusetts, New Jersey, New York, Oregon, and Virginia, where non-indemnity legal plans are substantially treated as insurance by the state insurance regulator. We also have seen legislative change in many states, those states being the state of Washington, Arizona, North Dakota, Nebraska, Texas, Tennessee, and also Arkansas. Vast majority of states don't view us as insurance, and so we're not regulated. This will also support, like I talked about, with access to justice and the real issue. You know, the judicial system can pose great challenges for somebody that does not have access to legal help. Civil matters can result in detrimental consequences. in such areas of like housing. Think about foreclosure, landlord-tenant, which I'm going to talk about, family law, child custody, garnishments, unemployment, all these different things that everyday citizens need legal help for, but they don't have that. States like Nevada are looking for options to address the need. Nevada, in almost every state in the United States in the last 10 to 15 years, has looked for ways to help provide legal help for their citizens. And Nevada did what my home state of Oklahoma did. Their Supreme Court actually put together a commission on access to justice to try to get help. And so our top court in both states recognized the issue. Legal aid, which I appreciate what legal aid does very much for citizens, but legal aid can only address a small number of citizens' needs. You know, most people don't qualify for legal aid. And if they do qualify for legal aid, legal aid doesn't handle many areas of law. On the other side of the spectrum, you have citizens who, a lot of them can't afford to hire an attorney at a full rate. And so that's where a legal plan comes in, that big gap of the majority of citizens with a legal plan, they can afford a monthly legal subscription, which gives them access. And so that's what I appreciate what we get to do and what the legal plans do for citizens. I wanted to briefly, just real quick, bring up the landlord-tenant example just to provide that. I heard a very tenured judge talk about this issue years ago, and he used a landlord-tenant case as his example, which you think a landlord-tenant matter doesn't seem like that big a case. But he showed for that family, not only did they lose their home, but then try to go find another home after you've lost one, right? After you've been evicted. If you have a judgment, that judgment's going to go on your credit. Then you can be garnished. It can affect your employment. And so he showed how just that one case snowballed in that family's life. And I appreciate in my own career, I was able to help a member years ago with the landlord-tenant situation. And when I went over to court with them, of the 10 different defendants that were on that docket, only one had counsel, and that was somebody who had a legal plan. So I want to bring to your attention briefly, and I'm almost to the end, and that is the New York Times just put out an article on this very issue, on access to justice. And one of the lines in the article says, it's dangerous to go to court without legal representation, but more Americans are going it alone. And this is still today in 2025. And so again, this legislation will support access to justice, will help us help more people. And with that, Assembly Bill 512 simply clarifies non-indemnity legal plans are not insurance products and should not be subject to the insurance code. And with that, I appreciate your time.
Madam Chair, Trey Abney, again, for the record, I'll briefly just walk through what the bill says, and then we're ready for questions. So let me start by stating that the new language in section 1 was inserted via work session by Assembly leadership on the other side. So Mark and I are not prepared to address that language. But Madam Chair, I don't know if you've heard of a guy called Adam Plain, but you'll see his exhibit online. And not to throw him under the bus, but Mr. Plain, of course, and Mr. Plain is here in a neutral capacity. But if you have questions about that section, he is certainly prepared to talk about it and is much smarter than me on that. Section 2's blue language is why we are here in front of you today. You will see that Section O is existing language, and that is where historically the Division of Insurance has considered legal service plans to be in the miscellaneous category of casualty insurance. What we have done here is add a new section and type of casualty insurance for legal expenses and outlined that if a plan reimburses or pays someone for specific legal services or legal expenses, that is an insurance plan. But to the point of our testimony, we included language that outlines what is not legal expense casualty insurance in section N subs 1, 2, and 3. And that would be the fixed prearranged payments language you see at the end of the new blue language. And so I just want to check with Mr. Nelms, make sure I explain that right in my non-lawyer vernacular.
Martin Elms, yes, sir, that's
All right.
correct.
And so with that, Madam Chair, that is a brief description of the bill, and Mark and I are here to answer any questions you have. Thank you.
Thank you so much for the presentation, Mr. Abney, and I think you lucked out this morning because Vice Chair Daley is presenting in Judiciary. Do we have any questions from the committee? Okay, I don't see anyone making any eye contact with me, so I will say thank you so much. You can step back from the table, Mr. Abney and Mr. Nelms, and we will open this up for testimony in support of Assembly Bill 512. We'll start in our physical locations. I don't see anyone coming forward in our physical locations, so we are going to move to the phone lines broadcast. Do we have anyone on the phones who'd like to testify in support of Assembly Bill 512?
If you would like to testify in support of Assembly Bill 512, please press star 9 now. Chair, you have no callers in support at this time.
Thank you so much. While we're with you, broadcast, do we have anyone who'd like to testify in opposition of Assembly Bill 512?
If you would like to testify in opposition of Assembly Bill 512, please press star 9 now. Chair, you have no callers in opposition at this time.
Thank you so much. Do we have anyone in our physical locations? Seeing no one in Las Vegas, but is there anyone in Carson City who'd like to testify in opposition of AB 512? I see no one coming forward, so we are going to go to neutral, and I look forward to seeing Mr. Plain, who's not graced us with his presence as much recently. So welcome to the table in neutral on AB 512.
Thank you, Madam Chair, members of the committee. Adam Plain, P-L-A-I-N, with the Nevada Division of Insurance. Division's neutral on Assembly Bill 512, as Mr. Abney and yourself have stated. We did submit written testimony. The written testimony does include some supplemental information. It's correspondence from the division to an interested party back in 2021 regarding the legal services product issue. So it has a little bit of explanation as to what the division's stance was. In a nutshell, because legal services insurance is not defined in statute, we've regulated it as a miscellaneous product. We use what's called a fortuitous event standard. Basically, if the product looks like the policy holder would, or the contract holder would benefit in a fortuitous manner from an unknown event, then the division considers it insurance. Assembly Bill 512 would put a definition for legal expense insurance into statute. So the division would no longer rely upon the fortuitous event standard and would no longer regulate it as a miscellaneous product. The agency has no preference whether we continue using the existing standard or under the new proposal under Assembly Bill 512. I would just bring it to your attention so you have some background on it. Concerning Section 1 of Assembly Bill 512, as Mr. Abney stated, not our language, but if you have questions, I'd be happy to answer them. Section 1, I believe, stems from an Assembly bill from the last session. There were some unintended consequences from that Assembly bill. The division had to pass an emergency regulation, followed it up with a permanent regulation, and now the new language in Section 1 proposes to adopt the division's permanent regulation into statute to give it a little bit more force of effect. And I'd be happy to answer any questions.
Okay, I don't see any questions for you, Mr. Plain, but thank you so much for being here and for being ready and willing to answer questions as always. We hope to see you back in this committee again soon. All right, we will see you Monday. With that, I don't see anyone else in our physical locations to testify in neutral on AB 512, so we will move to the phone lines. Broadcast, do we have anyone to testify in neutral?
If you would like to testify neutral on AB 512, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. Would you like to make any closing statements on? Okay, we will close the hearing on Assembly Bill 512. And we thank our presenters, and we will move to the next item on our agenda, which is Assembly Bill 177, which makes various changes relating to audiology, fitting and dispensing hearing aids, and speech-language pathology. We will welcome the Assembly member and her co-presenters. And you may begin when you're ready.
Good morning, Chair. Thank you so much, and members of the committee. My name is Cecilia Gonzalez, representing Assembly District 16. I'm a little under the weather, so I'm going to just give a brief overview, and then I'm going to kick it to my co-presenters. The speech language pathology, audiology, and hearing aid dispensing board licenses and regulates these qualified practitioners in Nevada. A speech language pathologist is an expert in communication and helps people who have problems with speech, sounds, language, social communication, fluency, and feeding and swallowing. An audiologist diagnoses, manages, and treats hearing, balance, or ear problems. He or she works in the field of audiology, which is the science of hearing and balance, and determines the severity and type of hearing loss a patient has and develops a treatment plan. A hearing aid dispenser is a licensed professional who fits, sells, and adjusts hearing aids for adults. At this time, I'm going to turn it over to my co-presenter to walk through the bill. Thank you.
Thank you. Good morning, Chair Pazina and members of the committee. My name is Jennifer Pierce, for the record, Jennifer Pierce, and I'm the Executive Director of the Nevada Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board. Thank you for having me here today to consider Assembly Bill 177. Before addressing the bill, I would like to give you a brief overview of our board, which was established in the 2015 legislative session through consolidation of the Hearing Aid Specialists Board and the Audiology and Speech Pathology Board, with the intent to increase licensing efficiencies for similar and overlapping professions, as dispensing audiologists were required to hold a license with both boards. Our board is composed of 3 speech-language pathologists, each of whom must represent a different practice area, including university, public school, hospital, or private practice, 2 audiologists, of which one must be a dispensing audiologist, 1 hearing aid specialist, and 1 public member. We also have an advisory committee on fitting and dispensing hearing aids, which is permanently established in regulation, and we convened a temporary speech-language pathology subcommittee this past year that worked on this bill and recommendations for future regulation revisions related to speech-language pathology assistance. The board is funded solely through licensing and other fees collected and operates with just a small staff made up of myself, our licensing coordinator who works half-time for our board, and an investigator used on an as-needed basis. On average, we're able to issue licenses within 5 calendar days of receipt of a complete application when hearing aid dispensing exams are not required. This drops to 3 days on average for expedited licenses by endorsement and approximately 90 days on average for applicants requiring dispensing exams. The board census at the end of March 2025 totaled 1,680 licensees, including 1,396 speech-language pathologists, 63 audiologists, 115 dispensing audiologists, 90 hearing aid specialists, and 16 hearing aid specialist apprentices. The board census has steadily grown by almost 700 licensees since the end of 2016, and 76% of our current licensees reside in Nevada. At the end of fiscal year 18, out-of-state licensees made up 16% of our census, increasing to 24% at the end of fiscal year 24. And of all licensees with an active Nevada employer on record, 94% practice in Carson, Clark, and Washoe counties. Assembly Bill 177 revises NRS Chapter 637B related to all 3 practitioner types regulated by the board, addressing licensing, scope of practice, and several administrative sections within the chapter. 2 sections at the end of the bill also revise NRS Chapter 391 related to educational personnel providing speech-language pathology services in schools. These revisions will result in increased consumer access to services, expanded licensing eligibility, reciprocity, and portability, reduction in licensing barriers with faster time to license, expanded scopes of practice, and alignment of the chapter with federal or other laws through the revision or removal of unnecessary, outdated, or obsolete references. Section 9 adds a new licensing path for speech-language pathology assistants, or SLPAs. Sections 2 through 7 add related SLPA definitions, and Section 10 addresses SLPA practice under supervision, SLP students, and related regulations. Comprehensive regulation revisions have already been drafted to further detail licensing, clinical training, supervision, and scope of practice. Regulation of SLP assistants is widespread nationally, with approximately 38 states licensing, certifying, or registering SLPAs. At least 10 other similar professions in Nevada already license assistants, including physical and occupational therapy, which are affiliated rehabilitation disciplines. Nevada has one of the lowest ratios of SLPs to residents. Data from 2023 indicates that we have 32.7 SLPs per 100,000 residents, almost half the national average of 60.8 per 100,000, and we believe that assistants can help fill this shortage. This new path also follows a 2023 regulation revision by the Nevada Department of Education, or NDE, wherein on or after October 1, 2026, a person holding a bachelor's degree will no longer be eligible to obtain an endorsement to teach pupils with speech-language disorders. Due to shortages in special education personnel, Nevada was the last state allowing this longstanding historical exception to allow teaching personnel with post-baccalaureate training to fill this critical need as under the direction of SLPs. After 10/1/2026, a master's degree and either a board license or a certificate of clinical competence issued by the American Speech Hearing Association will be required. Under the revised regulation, school district employees holding the active endorsement issued on or before 9/30/2026 will be grandfathered in and remain unaffected in their current roles as long as their endorsement remains active. Per Section 9, either a bachelor's degree in speech-language pathology or communication sciences and disorders or current NDE endorsement issued prior to 10/1/2026 will be required to obtain an SLPA license. Applicants must also have either completed 75 combined clinical observation and assisting training hours, or must do so under supervision in the first 60 days following issuance of the license. Section 18 addresses applicability of the chapter as it relates to licensees and school district employees, ensuring that board licensees working in educational settings will be subject to the requirements of this chapter, and only non-licensees holding the NDE endorsement issued on or before 9/30/2026 will remain exempt. These personnel will not be required to obtain an SLPA license and will not be subject to unlicensed practice while in the scope of their school-based employment. However, they may optionally choose to obtain licensure to explore new opportunities for practice in non-educational, contracted, or private practice settings. Sections 38.3 and 38.6 revise NRS Chapter 391 to address collective bargaining rights for these employees. This section was added and Section 18 was revised from the original bill in collaboration with the Nevada Department of Education, Clark County School District, and Clark County Education Association to ensure continuity for current personnel. Section 39 removes examination and separate license endorsement requirements for audiologists wishing to fit and dispense hearing aids in Nevada, required in addition to a doctoral degree in audiology. Both a written and practical hearing aid dispensing examination are required, for which combined costs exceed $400 on top of licensing fees. The practical examination also requires travel to Nevada with portable audiometric equipment and a second person to sit as a test subject. Only 12 other states require an audiologist to hold the separate endorsement to fit and dispense hearing aids. 9 other states require a written exam, and just 3 other states require a practical exam. Our exam pass rate data indicates that audiologists are well prepared to fit and dispense hearing aids, and there are few available options in our laws, regulations, or policies to fully waive these for experienced applicants licensed in other states. Currently, the exams may be deferred by out-of-state licensees through our temporary license, allowing immediate practice and providing 1 year to complete the exams. However, this only delays the burden. The board supports current legislation proposing membership in the Audiology Speech-Language Pathology Interstate Compact, which also does not require these exams or a separate endorsement to fit and dispense hearing aids. Sections 17, 19, 31, 32, and 33 of the bill remove the term dispensing from the title of audiologist, no longer differentiating which audiologists may fit and dispense hearing aids. And sections 20, 23, and 27 remove references to the endorsement of a license, which also currently adds an additional $50 to the licensing fees. Section 24 removes the requirement that an applicant for a standard hearing aid specialist license be certified through the National Board for Certification in Hearing Instrument Sciences, or NBCHIS. Instead, the certification will serve as an optional automatic qualifier for a license. This revision intends to change how licensing standards are met, as many of the same elements required to obtain certification will still be required without the certification itself, which is not appropriate as an entry-level requirement per NBCHIS, but more appropriately suited to experienced practitioners seeking advanced training and credentials. It's only required currently in Nevada and Utah. It requires 2 years' experience and a current state license to sit for the exam at an additional cost of $225, and may already be deferred by out-of-state licensees with our provisional license, allowing 3 years to complete training and obtain certification. Section 25 requires the board to adopt regulations to address hearing aid specialist and apprentice licensing and training, which already exist in NAC Chapter 637B, but would be revised to include standard license applicants. An exception is also planned to require only 1 year of training or licensure for an applicant holding an out-of-state license or having completed training in another state, which is consistent with the allowance for an apprentice to practice without direct supervision after 1 year. Section 28 addresses the provisional license currently available to those not holding the certification but otherwise eligible for a standard license, which will now simply address the required training and on-site work experience. Section 14 revises the audiology scope of practice to broaden language from cochlear implants to implantable hearing devices to encompass evolving technology, remove the requirement for a physician's request or order to diagnose, and add language to align with the FDA final rule on over-the-counter hearing aids to clarify prescription authority, which is also addressed in the revised scope of practice for fitting and dispensing hearing aids in Section 15. Section 16 revises the speech-language pathology scope of practice to clarify, without expanding the scope, using clearer terms that encompass the range of endoscopic methods utilized by SLPs to examine the throat, vocal cords, larynx, nasal cavity, and sinuses to assess and treat communication and swallowing disorders. Section 22 addresses fees charged by the board, increasing the maximum caps on the actual fees charged as established in regulation. While not a focal point of this bill, all actual fees, except one, are at our maximum caps. No fee increases are planned, and drafted regulation revisions will set fees for speech-language pathology assistants and hearing aid specialist apprentices that are lower than standard license fees. Revisions also clarify and expand eligibility for a 50% discount on initial licensing fees for all military-affiliated applicants, including Gold Star family members, as expedited license by endorsement is only available to standard SLP and audiology licenses. Finally, this section also provides new authority to waive fees as deemed appropriate. In other general revisions, sections 13, 32, and 34 make a number of changes to also align with the FDA final rule on over-the-counter hearing aids, which took effect in late 2022 and permits the direct retail or online sale of hearing aids to adults 18 and older with perceived mild to moderate hearing loss without a medical exam or prescription. Previously, only prescription devices could be labeled as hearing aids, though amplification devices were available over the counter for many years, and the final rule ensures that the public has access to hearing aid technology through regulated devices to ensure safety and effectiveness. Prescription hearing aids may still only be ordered, fit, and dispensed by a licensed professional. Sections 27, 28, and 29 clarify requirements for temporary, provisional, and limited licenses, and sections 30 and 39 streamline procedures for issuing expedited licenses by endorsement. In summary, it is our intent through this bill to both improve access for consumers and remove licensing barriers to expand eligibility, reciprocity, and portability for our licensees. Thank you again for your time today, and I would be happy to answer any questions.
Thank you so much. Assemblymember, is there anything else, or is that the close of the presentation? You guys are okay, perfect. And you made it just within that 15-minute limit. It was impressive. Do we have any questions from the committee? We'll start with Senator Scheibel.
Thank you, Chair, and thank you so much for the presentation. My question is, I think, less about the bill and more just about the practice of speech-language pathology and audiology here in the state of Nevada, because I understand the relationship between the two of them. Is the education actually the same to become a speech-language pathologist or to become an audiologist?
For the record, Jennifer Pierce. Thank you, Senator Scheibel. No. So in 2007, the doctoral degree in audiology became the terminal degree for audiologists, and it's a completely separate curriculum. There may be some overlap, but speech-language pathology and communication sciences disorders in a master's degree program is for a speech-language pathologist. So there's some overlap in somewhat, but no.
Okay, so what I was wanting to clarify, and I think you already did this, but as we're talking about the practice of speech-language pathology, we're talking about audiologists and fitting hearing aids. They're really two different career paths. You wouldn't likely have somebody licensed by your board who is switching between, like a classroom setting and then going to fit hearing aids. They're different careers, but I understand that they're covered by the same board because of the relationship between the practices. Is that accurate?
Correct. And historically, I think the two original boards that were merged, I think in 1979, was originally audiology and speech pathology. We have had just a handful of licensees who have held both licenses, but so possibly, but no, typically not.
Thank you.
We are going to go to Vice Chair Daley and then Senator Rogish and then Senator Ellison.
Thank you, Madam Chair, and I had some similar questions, and maybe we'll get to them as my colleague was just asking about what's the difference and what the process. But my first question is in Section 6, where it says that a person is allowed to have direct or indirect supervision. So what are we trying to? What's indirect supervision?
Jennifer Pierce for the record. So indirect supervision compared to direct would be the supervisor is available, but not necessarily on site and in the room line of sight supervision. So they have access to a supervisor, but may be doing that independently.
So they're on site on the indirect?
Yes, but it can also be through telesupervision. So not necessarily in the same physical location.
That was the next question. So telesupervision means they got to be on the computer talking, and then they hang up, and then they go do what they just talked about. Does it have to happen every time, or can it just be, I checked with them once a day, once every 3 days, whatever? So tell me a little bit about telesupervision versus, because we've had these discussions on many other boards where you have people and they're supervised. When do they have to be there? Is it how often they have to do it? So what is the actual supervision?
Jennifer Pierce for the record, Senator. So we established these in the drafted regulations. I have them in the room with me, but not in front of me. The SLP, the supervising SLP will essentially supervise the SLPA in a manner that is specific to kind of the competency level of the SLPA, their training, sort of where they're at in their career and their progress. And so it could be any one of those things that you mentioned. It could be that they're not necessarily doing telesupervision in the beginning. They can move to that later once the person has more experience. Direct supervision would mean that, again, the supervisor's in the room. Indirect or telesupervision could mean that they're checking in periodically throughout the day and or are on the call during the treatment session, but it could vary depending on the patient's needs and the setting.
I turned it off. So that my next question in the line as I was reading through the bill. So in Section 10, it says the board shall adopt regulations regarding the supervision of speech language, and you said you have some draft regulations. And I understand regulations, I support regulations, we can do a lot of things there that don't necessarily belong in legislation, so some people have different views on that. So what is it that you're anticipating in that? So the type of supervision like we just talked about, what's the number of people that you're thinking of having under supervision per licensee, et cetera? I mean, those are all relative factors. We see those in other actual legislation on how many they can have, and I think it's a relative question in this case as well.
Jennifer Pierce for the record. Thank you, yes, for the question. And we did draft that in our regulations. We put quite a bit more in the regulations feeling like that was going to be a much more lengthy section. So the supervising SLP will be allowed to have a maximum of 3 persons under them, made up of no more than 2 SLPAs, 2 SLP students, or 2 provisional SLPs. And a provisional SLP is someone who holds our board license, has finished their master's degree and is in the kind of 1-year clinical experience year that they need to earn the ASHA Certificate of Clinical Competence. Or they're called an under the direction of SLP currently in the Medicaid Provider Manual as well. And so then a SLPA would be allowed to have no more than 3 supervising SLPs per employer, because the subcommittee understood that they may have multiple employers and would need, the supervising SLP must have the same employer as the SLPA.
Understood, thank you. And I have a couple others, but I think the chair wants to go to some others and she'll come back.
Thank you so much. I want to get to Senator Rogich and then Ellison, and then we'll come back to Senator Daly, and then anyone else who has questions.
Thank you, Chair, and good morning, and thank you for bringing this. We need so many more people in the school districts, and I really appreciate your effort in doing so. I have a question with regard to the telesupervision. 2 questions. The first one being, is the supervisor actually within the state of Nevada, or can that person be outside the state coming through the television, or not the television, but the televised supervision?
Jennifer Pierce for the record. Thank you, Senator Rogich. The supervisor has to be a licensee in the state of Nevada. They must have the same employee as the SLPA, or employer as the SLPA. But I don't think that we've dictated in the regulation that they would necessarily have to be in the state. So as long as if you're treating a Nevada resident or are a Nevada resident who wants to be licensed, you would hold the Nevada license, so they could theoretically, I guess, be in another state.
Okay, but as long as that person's licensed as well.
Correct, in Nevada.
Which brings to the next question. I just wanted to clarify that there's not going to be a certain type of application used, a software application, where it may not be a person. It may just be, like an AI component to it.
Providing this, I'm sorry, Jennifer Pierce.
Providing the
Providing
supervision.
Yes. Again, I don't think that we thought to include that maybe in the regulations, but I can make a note about that. And again, I do have we've basically taken the, and I can send this along, but there's a definition that the American Speech Hearing Association has for telesupervision, and we adopted quite a lot of their work. So it would be similar to that. Thank you.
And before we go to Senator Ellison, just to confirm, it couldn't be, I would imagine, artificial intelligence, because artificial intelligence wouldn't be licensed in the state.
Correct.
So,
Jennifer Pierce, yes.
Okay. Thank you so much. And with that, we're going to go to Senator Ellison and then back to Senator Daly.
Thank you. And when you hit on, the apprenticeship program, or however you do that, my wife had to travel to Idaho the other day because they're having so much problems with the hearing aids that they bought from Costco. They walked in, and after making this appointment, the first thing Costco said, well, these things are outdated. She said, we just paid $5,000 for them 4 years ago. And then some other woman come out and said, no, we still have some of the parts. What got me was she traveled all that direction to get up there. And then I don't think this girl, I don't know, I wasn't there. But it seemed like to me that if they've got a certificate, they're under apprenticeship or something, there should be something posted that they are going through training or something. Do you do that?
Jennifer Pierce for the record. I would have to look in our regulations. I think that we do have, we may have a requirement that requires them to identify that they're an apprentice, but if they should also have their license posted, and that would identify who's working and if they're an apprentice.
Okay, if it wasn't for the woman that had the knowledge come out, she'd have drove all the way back, and that's not bad. It's a 3-hour drive each way, but she was upset when the girl come out and said, no, we can't help you, just leave. And it seemed like to me that's not a good way to do it when you set the appointment up way before. Okay, thank you.
All right, Senator Daly, you're back up.
Thank you. Thank you, Madam Chair. So we'll probably get to the part where I'm just trying to follow all of this stuff. So we had, I wasn't understanding some of the changes where you're changing ordering. So walk me through who does the prescribing, or who can, or is it both? And you have order or dispensing, ordering, fitting. Are those two different sets of people, two different licenses? And because we're deleting in, I think, 39, the dispensing audiologist. Is that what you were saying earlier? They had to have two different licenses if they were just an audiologist versus a dispensing audiologist. And so try to tell me, because I'm not sure, what are all the terms? Who does it? Why was ordering not included in some of the stuff, and what's entailed in ordering? So I just am not following the whole process because I'm not familiar with it, but you're going to tell me.
Thank you. Jennifer Pierce for the record. Yes, Senator Daly, I will. So start with Section 39. So the national standard is essentially that if you obtain a license as an audiologist, you can do anything within the scope of audiology, which includes fitting and dispensing hearing aids. In Nevada, historically, and I'm not sure of the history of this, but to fit and dispense hearing aids as an audiologist, we require the separate exams that we are trying to repeal. You pay an extra $50, you add this special endorsement to your license, and then your license reads A123 dispensing versus A123, and you're therefore authorized to fit and dispense hearing aids in addition to everything else. That piece of the audiology scope that involves fitting and dispensing hearing aids is essentially the whole scope for a hearing aid specialist. Hearing aid specialists are limited to just dealing with the hearing aids, the hearing testing and the hearing aids. So the ordering language came from the FDA final rule on over-the-counter hearing aids. And when that became effective, there was some initial concern in the professional community that because there's now this new legal category of hearing aids, which historically you could only call something a hearing aid if it was legally a hearing aid under the FDA, they've established this new official category called over-the-counter hearing aids. And so essentially the ordering language comes from guidance that was sent out to states saying, this doesn't change prescription authority for an audiologist or a hearing aid specialist to fit and dispense hearing aids to a person with hearing loss or other needs. However, we advise states to add this term ordering because it essentially clarifies that they have that prescribing authority. So the ordering would essentially be the prescription, the fitting and dispensing are the fitting, the setting, establishing, getting the molds created, fitting them, troubleshooting, et cetera.
And thank you. That makes it a little bit clearer. And then the speech pathologist people, although they're under the same board, totally different scenario. They don't do dispensing and all the other stuff and ordering. That would be the audiologist that would do that. So same board, two separate lines of disciplines. And I think that's what we were asked earlier. I think that was all I had. I just was not following it easily in the bill. So thanks for the explanation.
Isaac Tenorio for the record, IZACKTENRIO. I'm going to simplify it, I think, for the committee. I think this will kind of demonstrate what the board is. So the board is three professions in one, and I think that'll kind of help you guys demonstrate that there's three professions under one board. So it's speech language pathologists, ideologists, and hearing aid specialists. So the board is a little bit different than other boards here in Nevada. So it's three different professions operating under one board, which is why it's three different kind of professions, which is why you see a lot of why the bill is so complex. I think that hopefully simplifies it for the committee, understand why there's a lot of scope of practice in one bill. So hopefully that helps.
Thank you so much. I'm actually going to have Mr. Coulomé, our legal counsel, respond to the AI question earlier, just so we can get that on the record, and thank you.
Thank you, Chair Jeff Coulomé from the Legal Division. For the record, if it is helpful, Section 7 of the bill does contain a definition of telesupervision, which states that it means the real-time distance observation by a supervising speech language pathologist of services delivered, et cetera, et cetera, et cetera. So the way that I read that, it seems to me that the supervising speech language pathologist is a person and not a software entity, if that is helpful to the committee.
Thank you so much, Mr. Coulomé. And I don't see any further questions, so I thank you so much, and we'll have you all take a step back so that we can open this up for testimony in support of Assembly Bill 177. We'll start in our physical locations. I don't see anyone in Las Vegas, so by physical location, I'm looking at Carson City, and then we'll move to the phones. And you may begin when you're ready. Please state and spell your name for the record.
Chair and committee member. For the record, my name is Andrew LaPelbet. I'm the state chair for the United Veterans Legislative Council, and they have my card with the spelling because it's difficult. So we're here in support of the bill. I represent the 250,000 veterans in our state, as well as our active military and our Guard as it relates to laws in the state of Nevada. And we're in support of AB 177. You're probably surprised to see me. However, Section 22 in the bill clearly states why I'm here, and it covers our veterans, our active military, their spouses, and especially our Gold Star families who have suffered the greatest loss possible, a family member dying in service. Therefore, our position is in favor of this bill. Thank you.
Thank you so much for your service, and we love your tie.
There it is. Hello, Chair Pazina, Vice Chair, members of the committee. My name is Devin Ashoff, Deven Aschoff, up here on behalf of Toro University, Nevada. We just wanted to put our support for AB 177 and thank Assemblymember Gonzalez for bringing the bill forward. And we urge your support, and thank you for hearing it. Thank you.
Thank you both so much. And with that, we are going to move to the phones. Broadcast, do we have anyone on the phone line who'd like to testify in support of Assembly Bill 177?
If you would like to testify in support of AB 177, please press star 9 now.
Good morning, Chair Pazina and members of the committee. This is Sheila Bray, spelled Sheila Bray, with the University of Nevada, Reno. We would like to thank Assemblymember Gonzalez for bringing forth this bill. The University of Nevada, Reno currently has over 200 undergraduates and 50 graduate students throughout our BS, MS, and PhD courses within speech, language, and pathology. Assembly Bill 177 works in collaboration with the Department of Education and the need of our students in schools to serve the school system around the state. This bill will open up the opportunity to create bachelor's level SLP assistants who will work under the direction of certified and licensed master's degree or higher speech language pathologists. This bill has a dual benefit of not only increasing workforce development and workforce development of our SLPs, but it also increases access to care for those around our state. We would also like to thank the Nevada Speech Pathology or Speech Language Pathology, Audiology, and Hearing Aid Dispensing Board for including the university and our faculty that work directly with these students in discussions and creation of this bill. We are in full support. Thank you.
Thank you so much, Ms. Bray. Broadcast, do we have anyone else on the line?
Chair, you have no more callers in support at this time.
Thank you so much. While we are with you, Broadcast, is there anyone who'd like to testify in opposition on the phone lines?
If you would like to testify in opposition of AB 177, please press star 9 now. Chair, you have no callers in opposition at this time.
Thank you so much. We'll come to our physical location. Do we have anyone here who'd like to testify in opposition of Assembly Bill 177? I don't see anyone coming forward, so we'll go to neutral. Is there anyone here in the room who is in neutral who'd like to testify on Assembly Bill 177? Still not seeing anyone coming forward. Broadcast, long time no talk. Anyone on the phone lines who'd like to testify in neutral on AB 177?
If you would like to testify neutral on AB 177, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. I am missing Assemblymember Gonzalez, but would anyone like to make any closing statements? Okay. With that, we will close the hearing on Assembly Bill 177. And thank you again so much for the presentation and for answering our questions. And we are going to move to the final bill on our agenda this morning, which is Assembly Bill 319, which makes revisions relating to providers of health care. And we will welcome Assembly Member Orenlicker and any co-presenters. Welcome. And you may begin when you're ready.
Good morning, Chair and members of the committee. I'm Assemblymember David Orenlicker, representing District 20 on the southeast side of Las Vegas. And thank you very much for the opportunity to present Assembly Bill 319, which I'm sponsoring on behalf of the Nevada Board of Medical Examiners. This bill is largely about updating and cleaning up existing statutory language, and Sarah Bradley will walk us through those revisions very ably. Before I turn the presentation over to Ms. Bradley, I'll discuss a couple of other provisions that I put in there. Under existing law, we treat doctors educated and trained in Canada similarly for licensure to doctors educated and trained in the United States. If you get a medical degree and do a residency in Canada, it's just like doing it here. You don't have to do a new residency like a doctor trained in France. Section 14 does the same for doctors from the UK, Australia, and New Zealand. If they get their medical degree and residency in those countries, we'll treat them like Canadian doctors. And why did I pick those three countries? The American Academy of Family Physicians has reciprocity for board certification for doctors from those countries. So I figure if the Academy of Family Physicians trust those countries' training, we should too. The other addition is in sections 7, 68, and 72, and this says that if you're an adolescent, 12 to 18, you see a doctor for routine examination or advanced practice nurse or physician assistant, they should screen you for cardiac disease, just to make sure that if you have hypertrophic cardiomyopathy, it's not missed. And the conceptual amendment that I've submitted revises those sections after consultation with pediatric cardiologists. So there were two things they're supposed to do. The amendment deletes the second one because it's duplicative. And those are my additions. There also is a proposed amendment that came in just last night on behalf of Northeastern Nevada Regional Hospital, and I think there's a representative here who will talk about that. But let's turn it over to Ms. Bradley, who can work through the heart of the bill.
Thank you, Assemblymember Orenlicker. Sarah Bradley, Deputy Executive Director of the Nevada State Board of Medical Examiners, for the record. Most of this bill, I would say, is a cleanup, updating language, removing unnecessary provisions. Some important clarification, though, I just want to highlight for you, and of course, if you have specific questions, please do ask me. Section 6 clarifies what's meant by progressive postgraduate education. So existing law says that an applicant has to have done progressive postgraduate, but it's not explained anywhere. So this is our intent to explain that and make that more clear to applicants. Another important change is in Section 9 and also 82, the two work together. That is regarding the scope of practice for practitioners of respiratory care. So it's our understanding that Nevada is one of the only states that currently requires 2 licenses for those individuals to do their jobs. They have a license from our board, and then they also have a license from the Division of Public and Behavioral Health. So our intent here is to clarify that if those practitioners of respiratory care are doing testing that they're trained for, that's a part of their scope under our law, with a corresponding change to NRS 652-210, that they will only need the license from the board, because we believe that these are things they're actually trained to do and they do all of the time, and this would just simplify things for those practitioners. Section 10 also is important. We've had some requests for this. Currently, other license types are able to do care in Nevada under the supervision of a licensed person if they're a student in a program. But for whatever reason, that's not the existing law for perfusionists. So we're adding that so that our perfusionist students can do some training, again, under a licensed person. And of course, there's a doctor as well that works with perfusionists when they practice. Sections, there's a lot of them, 12, 13, 29, 31, 32, 33, 38, 42, 73, 74, 75, 76, 7, 8, 9, 80, and 81. Those changes are all regarding simultaneous licensure with our board and the Board of Osteopathic Medicine. So right now, anesthesiologist assistants and physician assistants can have a dual license and they get a reduced fee. This allows us to actually kind of enforce that, and if they don't get that second license from the other board, either way, we can actually ask them to pay that difference so that we don't have people saying they're going to do it, getting a reduced fee, and then not actually following through. There's some clarification that's pretty important in NRS 630.160. That's a very big provision. We use it all the time for licensure, but it's not as clear as we'd like. And so there are amendments to that provision. We are repealing 3 provisions that we don't need anymore. NRS 630.254, NRS 630.2693, 2692, and 1606. And we are also clarifying the endorsement provisions with regard to what a license in good standing, with that. And also there's one provision that's specific for military members, and so we're clarifying that in the provision so that is clear, because it says that in our fee section. It's a little confusing. So our fee section says it, but the actual statute didn't. And so we're updating that for clarity. And then we're also doing some streamlining and updating of our hearing procedures and administrative procedures regarding, now we're going to call, instead of just saying the complaint, which can be confusing because consumers file complaints, when we initiate discipline, we file really a charging document. And so those changes are to put the board's chapter in line with NRS 622A, which was added. The board had to start following that, I want to say in 2015, but I might be wrong about that. But it's a newer thing that we have to follow. The board used to have independent procedures. And so basically just getting rid of anything that's outdated and conflicts with that, as well as just incorporating 622A fully into our chapter. And I think that's a pretty good overview, hopefully, of the bill. And if you have questions, I'd love to answer them.
Thank you, Ms. Bradley. David Orentlicker for the record. As I said, there was an additional proposal from Northeastern Nevada Regional Medical Center that builds on a bill we passed 2 years ago for certified nurse anesthetists for rural hospitals. And I think Francisco Morales may be here to explain it.
Good morning, Chair, members of the committee. Francisco Morales, Francisco-Morales, with Brownstein on behalf of the Northeastern Nevada Regional Hospital. Our proposed amendment does just that. Last legislative session, this body unanimously approved SB 336, which allowed CRNAs to be able to select, order, and administer anesthesia within their scope of their practice and under the supervision of a physician in critical access hospitals. The issue that we have is that although we are rural, almost frontier, I would say, we show the same staffing challenges and recruitment challenges as critical access hospitals. We are not a critical access hospital because of our size. And this is particularly true now that we are in the process and very close to opening a 16-bed behavioral health center. So that bill did not apply to us. With the new regulations that were enacted, we basically now have the very difficult decision of either amending that law to make sure it includes us, because we are a rural hospital, or really having to go and find 2 anesthesiologists to work in Elko and potentially having to disrupt our birthing center and other services that we're providing. So that's all that this bill does. We selected a population cap of 35,000, so it really only applies to Elko, the city of Elko. The other hospitals that would potentially fall under this population cap, think of Boulder City, Mesquite, and other cities, they already are included because they have a critical access hospital already within law. So really this would only apply to Elko, something that we desperately need to avoid service disruption. So I ask for your support and happy to answer any questions. Thank you.
Thank you so much. I will say I've received numerous emails in opposition of this amendment so far today, so I think there needs to be a bit more conversation in regards to this amendment and whether it may endanger the bill. So that can happen maybe offline, that stakeholders can get together and discuss that particular amendment. But is the presentation complete otherwise, or are you ready for questions?
Madam Chair, I did have one more thing, and I
Please,
apologize.
proceed.
In my attempt to be succinct, I missed. We are also making changes regarding medical assistance and adding a reference to medical assistance to the Nevada State Board of Nursing. The reason for that is there's a lot of confusion regarding medical assistants, who can delegate to them, and what kind of tasks they can do. Currently, they're in our chapter. We get a lot of questions regarding nurses and their role with medical assistants. The Nevada State Board of Nursing does as well. And the Nevada State Board of Nursing already has a protocol for delegating to unlicensed persons, but just for clarity and allowing things to work more smoothly, part of our bill was to add a reference to medical assistants in their chapter and explain that registered nurses and advanced practice registered nurses can delegate to them. And again, they already have a protocol for this. They just weren't calling them medical assistants. And so we think this will help things work better in hospitals, doctors' offices, other entities and places where medical assistants work with both nurses and doctors. Thank you.
Okay, thank you so much, and thank you for the very thorough presentation. And for such a long bill, you finished in less than 15 minutes, which is very impressive. Do we have anything else to add, or are you ready for questions? Okay, wonderful. Do we have any questions? Senator Rogish.
Thank you, Chair, and thank you for bringing this bill. I did have a question with regard to Section 65. And so looking at the subsection 2, I was hoping you could explain a little bit further as to location. The language in the subsection 2 refers to a location that does not meet the requirements of subsection 1. And when you go to subsection 1, it sets out what those locations are. So I'm just a little concerned about what location
Yes.
are you referring to?
Senator Sarah Bradley, Deputy Executive Director, for the record. So the intent of this provision is we have a lot of situations, especially in medical spas and other kind of not as well regulated places, where procedures are being done sometimes specifically under tumescent anesthesia. And the reason that they do that is right now existing law says if you're going to do regular anesthesia, and there's multiple kinds and I do get a little confused, but you have to be permitted by the Division of Public and Behavioral Health in Health and Human Services. So most doctors' offices, I'm going to say 95, 99%, that actually do procedures in their offices, as well as hospitals, surgery centers, all of those places, they're already permitted and they can do anesthesia. And we're not concerned about them doing tumescent anesthesia, but we are concerned about it happening in places where there's not a permit, because what people are doing is they're not able to get the permit from HHS, and then they use tumescent anesthesia to do inappropriate procedures. And so our intent here is to clarify that if you have the permit, you can use all forms of anesthesia. But if you do not have the permit, you have to administer tumescent anesthesia under regulations that the board will promulgate. And I don't quite know what those will be yet. We do want to talk to our stakeholders on that. But it's just we're very concerned. We've had several patients almost die, in fact, while having procedures done in these unpermitted locations, and it's technically legal at the moment, and we're trying to dysregulate that. Just for the record, so tumescent anesthesia, as I understand it, is lidocaine and epinephrine mixed together and given to a person in an IV. They're actually awake, I believe, mostly while this is going on. And again, the thing that they most commonly do that we have problems with is actually liposuction, being done under tumescent anesthesia in an inappropriate location. Again, we've had several patients that we are grateful they are alive today after having that done. We've also heard of breast augmentations being done under tumescent anesthesia in unpermitted offices. Very horrific. And so that's our intent here.
Thank you, Chair. The other question I have is with regard to Section 70. If you go down to subsection 4, oh no, I'm sorry, down to subsection 2, under the new language, subsection 2C, I should say, with regard to the medical assistant and being able to possess and administer dangerous drugs. I understand there's supervision there, but what type of dangerous drugs are we discussing here?
Sarah Bradley, Deputy Executive Director, for the record. There are provisions on this in NRS 454 as well as in the Pharmacy Board 639. Generally, what they administer is vaccines. They are not able to inject, for example, Botox. That's permitted by law elsewhere. They are not able to administer other items, but yeah, usually it's vaccines, and those are technically considered dangerous drugs. They'll still have to be a doctor's order, of course, for everything that they're administering. So the doctor will be, this is existing law, the doctor will be, or the APRN will be examining the patient, writing the order, all of that. But then the MA is allowed to administer certain things. But again, not Botox, not fillers. You know, it's usually vaccines. I think sometimes they also will start an IV. They don't normally put the medication, as far as I know, and I do have representatives from the nursing board if you have more questions about that. It's basically allowing them to do what they do under the supervision of medical doctors and doctors of osteopathic medicine already.
And just a follow-up, Chair. Yes. If this individual is not licensed or certified, how are they qualified to do a vaccine or administer under supervision?
Sarah Bradley, Deputy Executive Director, for the record. The nursing board has a protocol, and I'm sure they may review it and update it. For the medical board, I can tell you we require training. So what we say in our regulations for medical assistants, they have to be trained in whatever tasks are delegated to them. So it's not allowed for them to be delegated a task they don't have training for. That training has to be documented in their personnel file. And the delegating practitioner at the moment, you know, for us, that is a physician or physician assistant, must know that they're capable to do that. And again, it has to be in their file. And so there are trainings, for example, on vaccine administration. There are trainings, bloodborne pathogens. There are certain trainings that I think a lot of them have, and that is in their personnel file. And if we receive a complaint, we ask for that information. We ask who did the supervision. You know, we ask about that, and we do look into that if and when we're aware of issues. Welcome.
Senator Ellison.
Thank you, Madam Chair, and thank you for the presentation. The amendment that was proposed by Northeastern Nevada Regional Hospital, they usually, the nurses or whoever's doing the help assisting, they're still under a doctor's care and in proximity to where the patient is, the doctor and the nurses. So why would this be any different than anybody else given the shot or whatever it is?
Sarah Bradley, Deputy Executive Director, from the record. I'm not as familiar with the proposed amendment because that was just received last night. And so I'll defer that question. And then if you have questions, I can try to answer with regard to physicians. Thank you.
Chair Pazina, through you to Senator Ellison.
You may go direct, and thank you.
Why we need this is because CRNAs are allowed to operate in that model in critical access hospitals. We are not a critical access hospital. We are a rural hospital. And so that's why we're proposing the amendment to clarify that model would apply to us.
And for the record, I totally agree because, you know, they have to fly a lot of people out, but they, you know, because staff, but that's a huge new, well, not very old hospital. But I've been there several times when they, you know, the nurses assist in almost everything. So I don't know what you're going to do, or Madam Chair, if they're going to have a meeting on this and get some language back, or what. But I think we're to the point where it's critical without it, with a doctor not having an assistant for helping with this project.
And thank you so much, Senator. I would say that we currently have letters, including from the Association of Nurse Anesthetists, that have come out in opposition. So they themselves have come out in opposition. So I would say it's maybe just a discussion that we have offline soon, very soon, because the deadlines are coming. And obviously, we've looked into some of the important aspects of this bill, and I want to see it move forward. So let's have those discussions with the Nevada Association of Nurse Anesthetists, as well as with others who have, after seeing the amendment, written in with concerns. So thank you so much, Senator Ellison, and thank you so much. I know that you'll all be working together to get something back in front of us, and we really appreciate it. Do we have any other questions? Okay. I did have one question. In Section 25, I noticed a part was deleted. It was 25(1)B in regards to a special license to a licensed physician of another state to come into the state to care for or assist in the treatment of a patient in association with a physician licensed in the state. We've all been talking for many a session about physician shortages, healthcare shortages, and I was curious why that part was deleted, and thank you so much again.
Of course. Sarah Bradley, Deputy Executive Director, for the record. That's being removed because we actually don't require them to be licensed. So NRS 630.047 has a provision that says, if a physician who's licensed in another state comes into Nevada to treat a patient in consultation with a Nevada physician, they just have to let the board know in writing, and no license is required. So we just want to remove it because it's a burden we don't need to have.
Perfect. Well, thank you so much. One last look around to see if we have any further questions. And I thank you all so much for being here this morning and for the very thorough presentation on a very lengthy bill. And with that, we will take testimony in support of Assembly Bill 319, and we welcome you up to the table. We'll start in our physical locations and then move to the phones.
Good morning. Dear Chairperson Pzena and members of the committee, my name is Kathy Dinauer, C-A-T-H-Y-D-I-N-A-U-E-R, and I am the Executive Director of the Board of Nursing. And the Nevada State Board of Nursing supports AB 319, in particular, Section 66 of the bill. Allowing nurses to delegate to medical assistants will not only improve access to care in our state, but will assist with workforce development efforts. I want to thank Assemblymember Orndlicher and the Board of Medical Examiners for bringing this important legislation. The board has been a great collaborative partner in this issue. Thank you so much.
Thank you, Madam Chair. Alex Tanchek with Silver State Government Relations, representing the Nevada Advanced Practice Nurses Association, or NAPNA. NAPNA supports AB 319, especially because it includes sections for the Board of Nursing to develop regulations regarding APRN supervision of medical assistants and the performance of clinical tasks. This will be beneficial because it will increase an APRN's capacity to provide health care to the full extent of their license, which, in turn, will increase the capacity for and the delivery of health care in our state. Thank you very much, and we encourage your support.
Thank you both so much for coming up today and for being here in support of Assembly Bill 319. With that, we are going to move to the phone lines broadcast. Is there anyone on the phone in support of Assembly Bill 319?
If you would like to testify in support of AB 319, please press star 9 now.
Good morning, Chair Pzena and members of the Senate Commerce and Labor Committee. My name is Steve Simpson, S-T-E-V-E-S-I-M-P-S-O-N, and I'm the Chief Executive Officer at Northeastern Nevada Regional Hospital in Elko, Nevada. I want to start by expressing my gratitude to the sponsor for incorporating our amendment into AB 319. Our concern stems from the passage of SB 336 from 2023, which permitted certified registered nurse anesthetist or CRNAs in critical access hospitals to select, order, and administer anesthetics. While Northeastern Nevada Regional Hospital, as a 75-bed acute care hospital, exceeds the federal definition of a critical access hospital, especially with the addition of our new 16-bed BHU or behavioral health unit, we face similar challenges related to personnel and healthcare needs due to our remote location. We believe the intent of SB 336 was to enhance access to high-quality care in Nevada's most remote areas by permitting CRNAs to practice to the top of their license. This amendment to AB 319 will allow our hospital to benefit from the provisions of SB 336, thereby supporting the same policy goal of bolstering rural healthcare. This will significantly improve our ability to provide healthcare access to residents of Elko and the surrounding rural areas of Nevada. Thank you for your consideration, and we urge your support for AB 319 with the proposed amendment.
Caller with the last three digits of 157, please press *6 to unmute. Please continue.
Good morning, Chair Pazina and members of the committee. This is Jacqueline Nguyen, Nguyen, representing the Nevada State Medical Association. Thank you so much for the hearing today. We actually were coming in support of the bill. Unfortunately, with the amendment that is being proposed, if it is adopted, our position might change. Unfortunately, we only received that language this morning, so we'll need further time to review and converse with our members regarding the amendment. However, I do know that in quickly speaking with the stakeholders, our priority, even with the amendment, is to maintain physician supervision of CRNAs, but we also see the many benefits of the remainder of the bill. So thank you so much. At this time, we are in support.
Chair, you have no more callers at this time.
Thank you so much. Broadcast, while you are still with us, is there anyone who'd like to testify in opposition of Assembly Bill 319?
If you would like to testify in opposition of AB 319, please press *9 now. Chair, you have no callers in opposition at this time.
Thank you so much. We'll move to our physical location. If anyone would like to testify in opposition of Assembly Bill 319, please come join us. And I don't see anyone coming forward, so we're going to move to neutral on Assembly Bill 319. And we'll welcome Mr. Kelly.
Good morning. My name's Patrick Kelly with the Nevada Hospital Association. We respect the Board of Examiners on trying to update the regulations, and we are neutral with respect to that. But I do want to talk about the situation in Elko. So two years ago, during the session, we were trying to help rural hospitals who are having difficulty recruiting anesthesiologists to rural areas. And it's even difficult sometimes in urban areas. So the idea was to put together a situation where the CRNAs could practice at the top of their scope of practice. And so that has been working for 2 years in the rural areas, but it was limited to critical access hospitals. Elko Northeastern is not a critical access hospital, but they're in the rural areas and they have the exact same problems that all the other rural hospitals have. So this bill, or the amendment, would put Elko in the same situation as all the other critical access hospitals in the state. So that's why we would ask your support. Thank you.
I believe Senator Ellison has a question for you, Mr. Kelly.
Thank you.
And thank you for bringing that up. You know, people don't realize that they might not be a critical hospital, but still we have a large population, like at the mines and a lot of construction work within the areas. My my grandson just died at the mines just recently, and so you need to be able to have them doctors. If they would have got him there in time, they would have been able to maybe done something better than what they have. But I really believe that Elko is a critical hospital for the population and the lifestyle that goes around there. So thank you so much for your comments.
Thank you, and I'm sorry for your loss, Senator.
No, thank you.
Thank you. I believe we have one more question from Senator Steinbeck.
Thank you, Madam Chair. So what keeps Elko from being a critical access hospital? What is the difference?
Patrick Kelly for the record. Critical access hospital is a federal designation, and you're limited on the number of beds you can have. So I think it's a 23-bed limitation. And so if you're over 23, you cannot qualify. Elko is over 23 beds, but as I said, they're still in what's considered a rural area of the state.
Thank you.
And there are other minor services and implications.
Thank you so much, and thank you again for answering questions as well. I don't see anyone else coming forward, so we are going to go to the phone lines and see if we have anyone who'd like to testify in neutral on Assembly Bill 319.
If you would like to testify neutral on AB 319, please press star 9 now. Chair, you have no callers neutral at this time.
Thank you so much. We would invite Assemblymember Ohrenlicher up if you have any closing statements. Waiving that, thank you so much for the presentation today, to you and to Ms. Bradley and Mr. Morales. And I would just ask, and I'd be happy to meet after this as well and connect you with those who reached out this morning so we can get this finalized quickly with deadlines coming. So with that, we will close the hearing on Assembly Bill 319, and we thank you so much again for being here today. And we'll move to our last order of business, which is public comment. Members of the public may provide public comment in person, by phone, or submit it in writing to the committee's email address. A reminder, it shouldn't have anything to do with the bills discussed today and should be germane to commerce and labor. We look forward to hearing your comments, and we ask that you clearly state and spell your name for the record. We'll start in our physical locations if anyone would like to make public comment, and then we will move to the phones. And since I don't see anyone coming forward in Carson City to the table, and there is not a person to come forward in Las Vegas broadcast, do we have anyone on the phones who'd like to make public comment?
If you would like to participate in public comment, please press star 9 now. Chair, you have no callers wishing to provide public comment at this time.
Thank you so much. I wish everyone this weekend a very happy Mother's Day weekend. And with that, we will look forward to...
Can I make a public comment?
Yes, we would love for you to make a public comment, Senator.
I would like to publicly inform everybody that the Judiciary Committee will be starting at 10:30 this morning. Thank you for your indulgence, Chair.
Thank you so much. So everyone who's headed to Judiciary, be there or be square in about 35 minutes. With that, have a wonderful Mother's Day weekend, and we look forward to seeing you back here Monday morning at 8 a.m.